My name is David Scher. I'm a partner here at Block, O'Toole and Murphy, and I'd like to talk to you about your rights when you've been hurt on the job. If you have been injured during the course of your employment, these are the things that you need to know. First of all, you are entitled to workers' compensation under New York state law. And what does that mean? Employers in New York are required to purchase and carry workers' compensation policies of insurance so that when their employees are hurt, regardless of whose fault the accident was, their employees are immediately entitled to bring a claim, a workers' compensation claim, before the Workers' Compensation Board, which is a state agency. And through that claim, the worker is entitled to be compensated for any related medical expenses and for disability payments for the time that the worker's out of work due to his or her injuries. So it's very important, if you're hurt on the job, to report the incident right away. That should be to your supervisor or your foreman or your boss or whoever in the chain of command you would normally report something like an accident to. Do it. Do it clearly, loudly, specifically, in writing if you can. Follow up with an email. You really want to document what happened to you in a timely fashion so that no one down the line can ever say, oh, if you really had an accident, why didn't you tell someone? So cover your bases and report your injury. Then hire a law firm that handles workers' compensation. Now, Block, O'Toole and Murphy, we help injured workers. And part of how we do that is by partnering with the best workers' compensation firm in New York. So we will make sure that your workers' compensation claim is handled professionally and well by an attorney, so you get all the benefits that you're entitled to. You may also have another claim, which we call a third-party claim, a personal injury claim, if you can prove that your incident was the fault of someone other than your employer. Now, why do I say that? New York state law provides workers' comp coverage, and that's great. The other side of the coin is the same law also stipulates that you are not allowed to sue your employer for personal injury damages. So even if your accident was your employer's fault, your sole and exclusive remedy against your employer is through workers' compensation. The question for us at Block, O'Toole and Murphy is there another entity, another company, another person outside of your employer who was negligent and responsible for your injury? And if so, then you can pursue different types of damages. For example, pain and suffering damages, loss of enjoyment of life, future medical expenses, future lost earnings. And in order to have those types of rights and those types of claims, you have to identify another company who's responsible. And that's where an experienced law firm like ours comes in, because it's not always obvious from the moment of an injury who's at fault for it. It could be that an owner of the property that you're working in, separate from your employer, is responsible for your injury because of a statute or a law that creates a duty for them. And you wouldn't necessarily know that as you're sitting in your warehouse or your factory or your office. That's why it's so important to contact an attorney after any workplace injury, because you may have rights that you're not aware of and couldn't possibly be aware of until you talk to a lawyer who knows the rules, knows the laws and statutes and codes, and knows how they apply to other companies. Whenever you've been hurt on the job, it's important to understand that there are several strict time requirements for bringing claims. And if you don't comply with them, you might never be able to bring a claim again. That's why it's so important, as quickly as possible, after you've taken care of your immediate medical needs, of course, contact a lawyer and make sure your rights are preserved. There are strict limits of time, for example, within which to bring a workers' compensation claim, within which to bring a personal injury claim. And those time periods, which are known as statutes of limitation, aren't always obvious. Some people may say, oh, the statute of limitations in New York is 3 years. And that's generally true for most negligent cases. But, for example, if you're suing a municipality, like a city or a town or a village or the state, the period within which to bring a claim is usually just 90 days. About 3 months from the date of your injury to bring a claim, or else lose it potentially forever. So, when you're in an accident, on the job, call a lawyer as quickly as possible. If you don't, you might lose your rights. If you'd like to talk to one of the experienced attorneys here at Block, O'Toole & Murphy for an absolutely free consultation, call us anytime, 212-736-5300, or visit our website, www.blockotoole.com.